The problem is you do see a lot of antisocial people succeed. Loneliness is as big a risk factor for ill health and death.
We live inside our heads.
You go cold turkey, you go into withdrawal.
There is a lot of value in the stuff that we struggle with.
Better Thinking, conversations with experts exploring all things psychology. Welcome back to Better Thinking. My name's Nesh Nikolic, and my guest today is Professor Kristy Martire from the School of Psychology at UNSW. Professor Martire's research aims to better understand the development of expertise, processes of evidence evaluation in criminal trials, and how to improve the communication between experts and lay decision makers in forensic settings. It was a great pleasure discussing the role of the courts, structural considerations that hinder communication between expert witnesses and laypersons, and interesting expert witness characteristics that can affect communication, such as defensiveness and dispositional confidence. Hope you enjoy this conversation as much as I did. Kristy, a big thank you for coming onto the program today. I'm really excited to talk to you, as I know that the world of, the courtroom, expert opinions, how these processes occur, in this strange world for many of us is complicated and confusing. And there's a real importance for people to, and certainly people like myself, to understand that space a little bit better. And I was involved in something recently which was a little bit nerve-wracking, but I love to find out more about your research and knowledge and understanding in this space, particularly with regards to the process of evidence evaluation in criminal trials, and how we communicate or improve communication between experts and obviously the lay people who are making a decision ultimately, particularly in forensic settings. So thank you very much for coming on, and look forward to this conversation.
Thank you so much for inviting me. It's a pleasure to be here.
Maybe we can start with, how did you get interested in this space? What led you here? Because it's a real niche segment of psychology and the legal framework and the like. How did you find yourself here? A
circuitous route, not a direct path, which I think is the case for lots of people. I think it's fair to say that I had a passion and an interest for forensic investigation, and I did have dreams of being a forensic scientist back in the day, but my actual sort of chemistry and physics, basic science abilities sadly let me down in that department, and so I didn't pursue that. I also had a failed start of an education in design. And by trying things and working out that I didn't like those things, I gradually honed in on the things that I did like. And psychology was one of those things. The science and experimentation of psychology I just loved. And the fact that there was a particular discipline of psychology, a forensic psychology discipline, just sort of brought the pieces together for me. I couldn't point to what makes it my passion, but from very early on it has been. And once I found psychology and I found that there was a postgraduate program in forensic psychology, I set my sights on that and just kept going.
And moving forward into that, obviously there's a bit of a niche in terms of looking at, for example, how evidence, the process of evidence, and how experts relay their points of view, how lay people understand it. What are the challenges that are in this space on a sort of more broad level that obviously bring rise to your research and your role?
Well, expert evidence plays a fundamentally important role in lots of criminal trials and civil trials and other bits of legal decision making. Courts realize they don't have expertise in all of the many different types of information that are relevant to resolving a dispute in issue. And so they sensibly take the view that they should get people who know more about that thing to help interpret the information for them, to help them make sense of it. but it creates this, it's a weird environment for communication. It's a very difficult decision-making environment in that you have people who don't know about a thing placed in this intensive kind of hothouse where they have to make a high-stakes decision, which has fundamentally massive consequences for the people involved in it. They're all diligently trying to do a really good job of it, as I imagine you would if you were ever a juror, as I was when I was a juror. You definitely don't want to muff it up. But the system itself is not necessarily well designed to communicate, to allow that transfer of expertise from somebody who knows a thing to somebody who knows nothing about that thing. And it's that sort of tension, it's the high stakes, it's the value of the expertise, and it's that tricky environment that it's happening in that makes it something that's fundamentally fascinating and I think maybe impossible to resolve, but that's what keeps you interested, I think.
It's fascinating. I have incredibly limited experience of N=1 of actually providing expert witness.
I'd love to hear about it.
It was quite recent. I think if something's been out in the public, can you speak about it? Is that allowed? I haven't even been advised if you're allowed to speak about it. I imagine once it's in the court you can, or
once it's in the public domain, I believe that you can, but to be safe, you might not mention names, just to make sure.
Does it matter if the proceedings are still ongoing?
To be safe, let's say it does.
Let me speak a little bit more.
You can talk quite generally. I think.
What I found that was interesting is, and I pride myself on this, whether I'm writing a report or in any other sense. I like, and I believe in the process of being helpful to the court. You know, I'm trying to do something for the court rather than advocacy. You know, and that's what psychologists are supposed to do anyway. I don't believe. You know, I think we should be clinically minded and therefore objective. You know, and I know that's hard because we don't want to upset clients and so on and so forth, and break therapeutic alliance and so on. But I think that's what makes a really good health professional, irrespective whether you're a psychologist or any other profession. But I noticed in that type of setting, as you said, it's high stakes setting, there's this urge to be defensive. You know, there's this urge to kind of be protective. You know, am I going to be misinterpreted? You know, am I being set up for something? And it's really strange because even talking with the party that wants to engage me, there's something about, you know, it's not a familiar environment. So you begin to act differently, or at least there's cognitive load in the defense, you know, that you're trying to somehow, it's almost like you're being, you're under trial. So and in some sense, your opinions somewhat are.
And should be.
Yes, absolutely. But it's a different environment. And so we start to behave differently. And you know, I like to say that I'm reasonably composed, but geez, it's hard to be composed in a brand new environment, in a high stakes game, in a, you know, for what I believe is it's a court case, so it feels important.
It is important
because there are people who are, you know, people's lives or decisions that will affect lives are at stake.
Yeah. I mean, you have kind of hit on one of the real challenges, I think, for experts, and that's of adversarial allegiance. You're put into an environment where it's, particularly if it's criminal or civil legal matters, where people are setting out to test you. That is the environment that you're going into. It's not about making friends. It's not about a dispassionate sort of exploration of what you know, like this conversation. It's not really a collegial interaction. It's purposefully adversarial. And the ego comes into play, I think, very quickly, and there's not much you can, well, there are things you can do about it, but you have to be mindful about it. You really do have to tackle it to try and maintain that composure, because there's a legal obligation to be objective and impartial and to serve the court. And when people are attacking you, it's not necessarily because they have a good reason to attack you. It's because it's their job to attack you. It's because there has to be scrutiny and there has to be challenge. And if they're attacking you on superficial characteristics, which we know is a common way people will do it, maybe that speaks to the quality of your science, in that there wasn't something more fundamental that they could be attacking, but it's definitely going to happen. And I also only have an N of 1 experiences in being an expert. I tend not to put myself forward for this role. I think it's quite difficult to research expertise and be an expert in that at the same time. It gets kind of complicated. But the one time that I did it, yes, like I empathize that feeling of having to defend rather than being able to participate in a conversation that allows for the full exploration of issues is a real challenge.
And it's really challenging because even during the I suppose, I don't know, questioning and then cross-examination, whatever the right language is, I saw myself trying, in essence, still having this battle of, I'm trying to be true to what the point is.
Yeah.
Trying to give something that's valid and true and a true account. But I'm also kind of wrestling with this fear of I'm going to be misquoted, or I've got to get everything right because it's going to be thrown back at me and it might make me look embarrassed, or which thankfully, my role was infinitely little, but nonetheless, it's frightening, and it's interesting because it then posed that question of, how does even that affect this whole process? Because it's not like we get any skills training in this. Not most, but I imagine many expert witnesses, it will be N equals 1, or even if it's N equals 5, you don't have experience. 5 is still 5
stressful days of your life.
It's still going to be clumsy, right? Like,
yes.
And so, I suppose it poses questions that are, I'd love to hear more about for you in terms of the problems that arise, even in the setting. How could we possibly potentially make experts more comfortable to be able to do that without having to wrestle with themselves, while still being true to the legal process, which is there is some adversarial component because it does need to be tested.
It does need to be tested. They're not allowed to take you at your word. They shouldn't take you at your word.
Yes.
Which I think is a really important part of the process. It's realizing that it's an opinion. That's what you have. It's an opinion. It's hopefully informed by specialized knowledge and training and experience. But in the end, you weren't involved directly in the case, I presume, if you're being called as an expert witness rather than a fact witness. So you're making inferences. You're applying your knowledge to a set of facts and you're trying to reach conclusions. And so it's a particular type of decision making that jurors and judges and other fact finders are called upon to do. They're trying to work out if your inferential process does it have a firm foundation, and has it gone to a sensible, logical place that they can rely upon. And the fact that you're so mindful about representing your science well and not misspeaking and getting it across correctly and accurately and fairly, those are all good hallmarks of good experts. Somebody who I would rely on more, who I think the evidence says we should rely on more, is someone who is modest and circumspect in what they can say. They're careful and they correct themselves if they misspeak. They don't overstate their claims. They acknowledge limitations and weaknesses. that's what science teaches us we should do. We should be as precise as we can be, but we should also try to give a sense of what the limitations of that are. And the experts that I'm concerned about generally are the experts who are less of those things, who have a level of confidence that might not be commensurate with their capabilities and their competencies, who speak more certainly than the evidence base can sustain. And that creates a bit of a tension, because generally we like to hear from confident people. We tend to believe confident people. We like sureness and certainty. Jurors do, judges do, lawyers most certainly do. And unfortunately, the correlation, the relationship between that sort of interpersonal certainty and the accuracy or the quality of the opinion isn't as robust as we might want it to be. So it's a bit of a tension there.
Is there, and I don't know what the research says or from your knowledge, is there a moderating mechanism of confidence, or strong ego, someone believing in their opinion strongly despite the evidence potentially being challenged effectively in cross-examination? Does it still tend to sway, so to speak? Is there and I don't know how this would even be measured or tested, but I'm sure you could probably actually do tests when you're doing control and an experimental group. But if someone's speaking with confidence, does that actually have a greater effect on decision makers, so to speak?
Unfortunately, there is an impact of sort of disposition or confidence. There was some work that was done by a colleague of mine, Dr. Mariam Yunan. During her PhD study, she was looking at how some of the extraneous attributes of an expert might affect their compellingness or their convincingness, how persuasive they are. One of the things that she was looking at is this dispositional confidence, ego, and we were manipulating the objective quality of the evidence in terms of its scientific rigor, the underlying principles of the evidence that they were presenting. And we also manipulated the demeanor of the person who delivered it, their choice of words. So it wasn't the substance that changed, it was just the delivery. And while we did find that people care about confidence, care about quality, people are more convinced by higher quality evidence than they are by lower quality evidence, we did find evidence of what we have called, just among friends, the arrogance tax. And there was a consequence to just being too arrogant, too sure of oneself, in that someone who was arrogant could have their high quality evidence basically discounted to the same quality, to the same level of persuasion as lower quality evidence. So there was this penalty for being unpleasant.
Wow, it's almost like the inverted U type of performance thing. If you're showing confidence, it has some sticky component.
Yes.
Believability.
Yes.
If you overdo it, that arrogance tax, your
Right.
performance goes down. And obviously, if you underdo it, it's not as believable. The confidence somehow moderates.
We didn't find a lot of we didn't find sort of a floor effect in that there wasn't evidence that somebody could be, at least in the materials that we use, like there wasn't a floor effect from having not enough confidence. It seemed like people would sort of imbue you with a certain amount of confidence anyway, because you were an expert and you were testifying. So there was kind of like a baseline level of confidence. We couldn't get that to decrease or increase, really. All we could do once we went to that high level of confidence was see the penalty that was associated with it, which was interesting.
That is so fascinating, because it just shows how so much media acts I'm kind of moving a little bit further away, but people in the media are often very confident of their position,
Yes.
their viewpoints.
Yes.
And with that comes a compelling nature.
Yeah, it does. But there's a tipping point. I think when you mentioned an
Yes.
inverted U, I don't think we had quite the right conditions to find that inversion, but I have no doubt that there's like a sweet spot where
Sure.
confidence and persuasion are sort of nicely aligned, or at least the more confident you are, the more persuasive people think you are. But then there is this kind of cliff, I think, where you just become a little too much, a little too sure of yourself, a little too full of your own sense of self-worth, and then there starts to be a penalty.
I like the word arrogance because I think we've all experienced how we might reduce someone's status, someone's opinion, once they get to a point of being so sure of themselves, or even kind of dismissive of others. You know, it
Yes.
almost kind of in and of itself infers that there are blind spots. You know, there's an
Exactly.
unwillingness to consider the other
Yes.
side.
Yes.
You know, and that often comes with, you know, huge generalized statements that, you know, thankfully in a court would hopefully be put under scrutiny, but nonetheless, the confidence still holds more than the same message, but a certain level of confidence makes it stickier.
Yeah. It's a question we get asked about a lot, because we know from research that the relationship between confidence and accuracy is generally quite poor, because there's a difference between someone's demeanor or personality confidence and their capability doing a particular thing. Those are two different sorts of aspects of a person's performance. And people in this area have anecdotes of very confident witnesses who are saying things that weren't particularly well supported, and they tended to be believed. So there is kind of a problematic relationship there that we need to be careful about. And part of what we do is do education with courts and with lawyers and other people who are leading evidence or receiving evidence, to try and help them see through that superficial bravado and pay more attention to the underlying quality of the evidence that's being given, so they don't get too distracted by the interpersonal style, which can be without particular substance.
And is that something that a jury, for example, would be also educated on for a period of time, or they're, you know, jurors are lay people, they get very little instruction. You prime jurors as to how to do a good job,
so there are instructions given to jurors usually when they're receiving expert evidence. An interesting thing that I didn't know was true about judicial instructions, and that runs counter to how I think most lay people feel like instructions would go, and how most psychologists certainly feel like instructions would go, is that the instructions often come after the evidence has been presented. So you might see the expert and you might receive the instruction about how to evaluate the expert evidence at the end of the trial, which may be days, weeks, years after the expert has actually been presented. So it's not, from a psychological perspective, it's not really well designed to help people anticipate the evidence and plan how they're going to evaluate it. It's an after the fact instruction most often. And then the nature of that instruction that they get, from memory, I don't think it refers to confidence. It just directs them to not take the expert opinion at face value, to think about it critically and to decide whether or not they want to accept it. I think it gives them permission to decide not to believe the expert, which is an important thing to do, because otherwise I think there might be a tendency to just believe whatever is presented. So being given explicit permission not to believe what is said is good. But the instruction itself wouldn't be based on, it's not based on what we know from psychological research about what are the hallmarks of expertise or how should you evaluate an expert. It
sounds
more of a global warning.
Yeah, it sounds a little counterintuitive to do it afterwards in terms of the instruction, because sometimes and look, I might be speaking out of turn. I don't know quite how memory works and impression and so on, but just purely on, from a conversational point of view, sounds counterintuitive to do it after the fact, because sometimes you integrate that information without questioning it at the time, and then go back in retrospect and say, I'm going to have to remove the parts that I've integrated in real time. Would be much harder than if you give me the instruction up front. And I would suggest even getting the instruction updated and told to you each time a new expert witness has come up, because I think you do need those prompts, those reminders. No different to how a coach might say to their student every single time they get up on this, on the blocks or the, on the court or whatever it is, that they repeat the same stuff because we need prompts. Athletes are prompted all the time. So it sounds quite counterintuitive. I don't know. Is there something in the literature around that, or something else that speaks to which way psychology might prefer it to be?
Well, I think everything we know about learning and education and forming knowledge, I think it suggests that information like that would be better placed up front before the evidence is presented rather than after. But that's one of the fascinating things about working in legal contexts, is that the law system has evolved on its own over hundreds of years to serve particular purposes. It's not constructed the way psychologists would sit down and design it. And that's, a point of fascination, is when you are a psychologist and you look at this system that has iteratively evolved, and it's got its own traditions and its own reasons for doing things and its own rules for how things should proceed and take place. And very often you find that you have a naive expectation, perhaps as a layperson, but certainly as a psychologist, about the sensible way this should go. And it very often doesn't follow that path for whatever reason. It doesn't. And then legal systems are very slow to change. It's very hard to advocate in a way that's ever going to allow a criminal justice system to suddenly shift from the kinds of procedural approaches that it has to the ones that we think might be psychologically optimal. And this is just one example. So instructions jurors, for example, you may not know, or you might know but haven't really thought about it. Jurors might be sitting for weeks in a trial being presented evidence. They are formally not allowed to discuss that evidence until all the evidence has been presented. So they are expected to sit relatively passively in a room for weeks at a time, taking in information, and not do anything with that information until they have it all. And then they are asked to go and deliberate and to make a decision. That's why the instructions come at the end of the trial, because technically the person was meant to be sitting there just listening for the entire time. And we know that that's not how you can't remember information like that. You can't really engage with information like that. The passive spewing of information at somebody for 2 weeks is not going to be the optimal way to engage with it. But that's the expectation. It's not what psychologists would suggest. And it's why you get a chunk of instructions at the very end of a trial telling people now how they can reason with the evidence, which is odd.
Yet I can also see if the first point was abided by, held, where jurors sat in a room, they didn't speak to one another. Don't know what planet we'd be on, but let's assume that occurred. Then it might make sense because in actual fact, you're saying, great, we want to go out and reserve judgment until the end. Otherwise, I know an expert witness at the start of the trial might have more influence, because if we then have a conversation over and over, collecting information from the beginning all the way through to the end, they've had a more significant voice, so to speak. And, a greater weight could be placed on that if we're discussing it. I mean, in theory, I think a greater weight, maybe they also call witnesses in specific ways also. to put greater weights and develop a story as well. Maybe you can tell me a little bit about that, but I can see why the instruction might come last. Having said that,
Yep.
I'm assuming the first assumption I said in terms of jurors sitting in a room silent, it's
Yes.
probably not occurring.
No.
Because they're human.
Also, you as a listener isn't sitting there silently, just passively receiving information. You're trying to connect that information to things that you already know. You're thinking about what you don't know and what questions it raises. You're sitting in a murder trial. You've already got some kind of naive hypothesis about whether the person has done it, or,
Yes.
you know, your brain doesn't, it's not a tabula rasa, you know, we don't have this blank slate situation happening, and the law has this expectation that we do. It kind of wants us to, well, adopt a presumption of innocence, that's what it would like us to start with, and then just work from there, get all the evidence, then make a decision. And unfortunately, that's not really how human cognition works. So
Sure.
It creates tensions that are fascinating.
Are witnesses brought forward in particular in a particular order? Is that something that's negotiated between the parties? How does the legal system deal with that? Who leads that, or how does that get influenced in a trial?
I think it happens on a case-by-case basis, and I'm not an expert in trial craft, so certainly a lawyer would have better insights into this than me. But the prosecution always goes first. So when we were talking about expectations and who gets to have the first narrative, the prosecution always gets to have the first narrative. And then, you know, I think it very much depends on the practical realities of the case. If you have a well-funded defense and a high-profile type event, then maybe there are resources to be spent on that kind of staging, on developing a narrative and on presenting evidence to progress that narrative in the most sensible and logical way. But probably in the vast majority of cases, which are relatively comparatively trivial matters, you know, routine traffic matters or drug offenses or, you know, common assault, you know, sort of, I don't want to diminish the experience of any of these things, but, you know, maybe quite quick matters, there might not be the resources available at all. You're often dealing with legal aid who are completely under-resourced. Many of the people who get involved in the criminal justice system have limited financial resources to be able to mount a defense beyond using the freely available resources. So it's often the case that the defendant doesn't have a lot of resources to bring to bear to construct a beautifully told narrative, whereas the prosecution will have more. And even then, practical issues come into play. So I always naively thought that the structuring of expert witnesses and other evidence would really be about walking somebody through a narrative, you know, trying to tell that story. But when it comes down to it, it's about witnesses who are available on what days, within which windows of opportunity to hold the hearing. So even in terms of building a beautiful, coherent, logical narrative that somebody can follow, oftentimes it won't happen that way. You'll have a piece of evidence on a day because somebody was available and its relevance might not become entirely clear until later in the trial, or
yeah, that makes sense.
Just has to be dealt with on a piecemeal kind of basis.
Well, I did a similar thing in my N=1 where I was actually overseas at the time, and
right.
So I did it like this video.
Yep.
And because I was on, you know, a significant family holiday that happens, you know, once in a lifetime in terms of the significant time I took away, I was a little bit firm on what I could and couldn't do.
Exactly.
Because it was going to genuinely affect time with family. And so I kind of made... I was still quite flexible, but there were actual times where I said, oh, I'm not actually going to be able to do that because I'm flying.
No. Yes.
Right. And so I'm sure if someone had the budget, they can move all those things because they can pay for all sorts of stuff to
Sure.
incentivize, and and that's probably where
Yes, right. We'll pay you more so you can be here.
Right.
I'll reschedule your family's holiday for you.
Yeah, I mean, Hollywood would, I'm sure, achieve it, and all sorts of things because the pockets are just ginormous. But we're talking about general people, normal.
We're talking about general people. We're usually talking about fairly run-of-the-mill matters when it comes to, what courts are used to dealing with. We're talking about people who don't have a lot of financial resources. We're talking about a criminal justice system that's stressed.
Yeah.
So the
optimal
rarely happens.
Yeah. What would a recommendation be, or your viewpoints, or even from some of the research that you're aware of about changes we could make to facilitate or support this improvement of communication between the expert and the layperson? One thing that I am aware of from a different podcast that I recorded some time ago now was considerations about even how evidence is in the room. Like, for example, making large pieces of evidence can sometimes make it more compelling. So, for example, if someone said, they fraudulently, signed on this, on this document, and then you bring out a little A4 page, versus if you blow up this thing, it's like there's a bit of there's theater, but it makes it, and then you put this big red, circle around where the criminal act of signing occurred. That all has affect, and the recommendation was, that there has to be some limits. So
I'm glad you were going there. I'm glad that's where you ended, because I think you said it well. There's a lot of affect there, and I think rigorous science and emotion are not usually the best of friends, right? You're trying to help people make well-informed, logical, evidence-based decisions rather than triggering the affective reactions. So I think care does need to be taken. I would take a step back. I think the problem of communication is so fraught. It's so fundamentally difficult. It's on some level, it's always going to be intractable because you've got somebody who knows, hopefully, everything there is to know about a thing, and it's a career's worth of study and thinking, and they're trying to impart all the complexity and nuance of that to somebody who knows nothing about this thing. It's a very difficult problem to solve. So we often, when we're talking about how would we like to solve this problem, we take a step back and we think about, well, can there be ways to minimize the likelihood that people are going to be presented poor quality evidence in the first place, so that the risks associated with their evaluation are lessened because the information they're getting is better quality. And so that's down to judges and legal rules of admissibility. Can we do more to help judges become better evaluators of evidence and make better sort of screening decisions about who will be allowed to testify and under what circumstances? Judges do have a gatekeeper role in our criminal justice system. And I think people tend to have the view that if an expert has made it into the trial, then they've been given the stamp of approval by the court, and that what they're going to say is going to be generally sound. But close inspection of those evaluations show that very often courts will admit experts who don't have good foundation and who are saying things that aren't well supported. And so really tightening up that first step before the communication even before you even attempt the communication might be a more impactful step than refining the act of communication itself.
That makes sense, because I do recall, and it probably went in different directions, so it might not fully connect with what you're saying here, but I do remember very early on in my career, I was also flagged to provide expert witness And after, almost a day of sitting around waiting, I went into a room with the, I suppose, defense. And then afterwards, I went to a room with the prosecutors. And they both had an opportunity to ask me a series of questions that weren't in the court. It was just a side room.
Yes.
And I recall doing an absolutely appalling job. They both shredded me to pieces, scared the daylights out of me, just because I didn't have reasonable answers, and I think because of that is why the defense said, we're not going to.
They decided not to lead,
because that's not going to be very helpful to probably our position, I think, in retrospect. Although I'm sure they would have liked me up there, but what I was about to say was probably didn't hold water once it was being scrutinized.
Sure.
So I can see how, will it enter or not? But on that basis, it would have been because defense, I'm assuming, I'm making all this up, but I'm assuming they pulled it because it wouldn't have been healthy for them. But at the same time, I was young. I had no instruction. I had no idea.
Prepared you better.
Yes, I'd written a letter that they would have loved to have used. It was for a different purpose, but it was useful for them at the time. And, they wanted to submit that. And I would have kind of vouched that it's a reasonable letter. But when it came down to it, it just didn't hold any water. Too many assumptions in it, and the like.
It was produced for a different purpose other than an evidentiary purpose. And you do have to think about evidence in a different way to the way that you would think about a letter that you would write.
And it was very helpful in my early career because it allowed me, from that point onwards to caveat everything and be a lot more scientific in what I'm writing and how I write. Because it's quite embarrassing as a
doesn't feel great.
So-called, theoretical expert just in my field. Maybe expert's not right. We're not allowed to use that word, but someone who's done the work. I should have better skills, and that was nice and humbling very early on in my career to go and say, we can't make these ridiculous statements. That was I'm sure the client was very happy for the purpose of why I wrote it in the first place, but maybe that was more potentially even like advocating rather than a psychological opinion that wasn't afraid of rupturing the therapeutic alliance.
Yes.
And so
those are very different tasks.
I can see how human beings, psychologists, can be clumsy in what we do, and hence why I think senior psychs are doing supervision with juniors, and now I share that now with everyone I meet, and when I look at reports that go out, I've always got something to say because there's plenty of assumptions in every report, and I'm caveating everything. Or close to, but I think there's something healthy in that.
Very healthy,
because it's important that because there's still a scientific method being held there, and the great challenge of doing that in a courtroom is it's hard, and the process is hard, and the guidance is hard, and I think it's even hard for people like judges, even though they're unbelievably experienced, let alone the lay people. The lay people who are either lay people but know their profession, or a lay people that are supposed to give some sort of guidance as well as to whether something is probable or not, or beyond reasonable doubt or not. But don't know where
jurors jurors definitely do have a very difficult job, but I think it shows a level of sophistication that is something that we do come up against with psychologists offering expert opinions, but also with other people. It's that explicit awareness that something that's undertaken in a therapeutic clinical role or in an advocacy role is not the same as what should be going into a courtroom. And people do express concern about psychologists who aren't sort of familiar with the adversarial or with legal environments, who don't really understand the obligations of an expert in those environments, to sort of generalize skills that they've learned from therapeutic interventions or from advocacy into a legal context. And it can create evidence that is problematic because it isn't appropriately qualified and caveated. And people say things that they believe to have been true, that they think is based on the evidence, but they haven't provided the information that actually shows the connection. They don't include the citation, or they don't really drill down to whether or not this thing that I'm saying can actually be backed up. And it's that sort of unfamiliarity. It's what people don't know about moving their expertise into a legal environment that can cause the problems. There is a skill to being an expert witness. There are obligations, there are ethical requirements, there are codes of conduct. And it's not just psychologists, but when anybody sort of thinks that they can just jump into this environment, it is a risky proposition. There's a lot you need to know to do it appropriately.
Can I ask you about how your N=1 experience was? And
don't get me started.
To be discussed. Some of that might be helpful contextually as well.
Yeah. So my N=1 is quite unusual, not only for me, but just in terms of expert opinion, I think. So I actually was participating in a public inquiry in Canada. So it was kind of like a royal commission. In Canada, there had been a horrific mass casualty event where a perpetrator had killed a number of people, set a number of fires. It was a devastating event in that community. And there was a public inquiry being held into what had happened, what led up to this event, and how could it have been prevented. And as a part of that, a psychological autopsy was produced somehow. And the reason I say somehow, I'll try to explain in a moment, but a psychological autopsy was produced. And for those of you who don't know, which is probably most of us, a psychological autopsy is meant to speak to the psychology of a deceased person in the time prior to their death. So the origins of psychological autopsies were kind of around understanding precursors to self-harm and suicide, maybe to help differentiate between whether or not this death was accidental or intentional, self-inflicted, or something else. So there were people who would look back at the person's life and try to work out whether this was suicide, basically.
And I'm assuming that it just involves from any reference points, whether there has been counselling provided, psychology provided, or not. It could be interviewing friends, family, people known to the person, if they've been involved in the law or not, and so on. So schools or something.
So it's like a data collection.
Psychological record, but it kind of says what frame of mind, what sort of life did this person lead, to try and get it and understanding. Is that what you mean?
Yeah, so that's the idea. It's about saying we can't speak to this person now. We have questions, and it's about trying to look back and see if you can make an informed estimate about where this person was at the time that they died. So a psychological autopsy had been created in the context of this event, and my colleague Tess Neal from Iowa State University and I were approached to speak about whether or not this psychological autopsy was rigorous, whether it constituted a psychological autopsy that followed scientific best practices. Because we are interested in, good quality psychology, good quality forensic psychology, and what an expert would do in these kind of circumstances. So to participate to provide an opinion about that, we asked to remain blind to the case details. So we didn't want to know about the mass casualty event, because we know as psychologists that knowing about prior information can really shape how you're going to approach new information. We said that we didn't want to know, we didn't want to see the psychological autopsy at first, because what they were telling us is we want to know what is best practice for a psychological autopsy, and we want to know if it was followed in this case. So we proposed that we would go to the literature, we would come back to them with, here is what we think is best practice for doing a psychological autopsy. Then we would ask to see the psychological autopsy and assess how well it performed against those criteria. So we're really trying to protect our own judgments from prejudicing or biasing factors. And then once we did that report, we traveled to Canada and we participated in the public inquiry. And for us, that meant, I think, about 8 hours of testimony in a hotel ballroom with, we were cross-examined by 3 groups of lawyers who were representing, I think it was maybe 8 groups of parties that were invested. So the police had a lawyer there, family members had lawyers, various other organizations had lawyers, but then there was also family members of all of the people who were affected in the mass casualty and a lot of media. So the whole thing was live streamed in Canada every day of the hearings. So we had microphones and we're on a stage. And when you're talking about your first time being an expert witness, it was, I'm going to call it, on the intense end of those experiences. And although it wasn't meant to be adversarial, this was meant to be an inquiry. It was meant to be looking back and trying to work out what had happened. It definitely took on a bit of an adversarial flair, because as it turned out, we were quite critical of the psychological autopsy. It didn't really match with best practices. And that, as it transpired, turned out to be not great for some of the parties that were involved. And we learned more as time went on, but yeah, in the end, it spoke quite harshly about the police agency that was involved in the policing, and a psychologist who produced the report and various other things. It got a bit complicated in the end, but sure. You can still watch that online. It's on YouTube. There are there's videos of it around out there. It's a long watch, but there's some interesting online commentary if you're into that kind of thing.
Look, it sounds like it's incredibly both important in the first instance, but incredibly complicated as well. You know, to go out and do a psychological autopsy sounds like, you know, the resources would need to be phenomenal.
I think to do it well,
yeah,
we didn't offer a psychological autopsy because, as you may have sort of hit on when you were thinking about describing what it was, it's very hard to know if you've come to the right conclusion when you're doing a psychological autopsy. This person is deceased, and so you can't ever really know what they were thinking at the time. And as it turned out in this case, the person of interest had never seen a psychologist, had never had any counseling. Nobody knew, there was no manifesto or journal or anything available. So it's the amount of inference you had to make to talk about their psychological state was quite a lot. Yeah.
I think it's painfully difficult to even do that with somebody that's
sitting right there.
Right. Because, you know, as a matter of fact, part of our work, I think, to be a great clinician is to refrain from also connecting narratives that could easily and nicely come together, because they are so nice to explain things.
Yeah.
But once again, they're purely, in most instances, at least in my experience, are made up.
Yep.
They're unbelievably convenient. Geez, they slot in together perfectly well. And that would be with someone that, you know, give me 100 hours and with my client and resources, and I'm still making it up. As a matter of fact, half the time that the client doesn't know themselves, and they'll change it as they go because we don't know. And hence why psychologists have to be objective and be so careful, because we can tie things together for clients very easily because they're vulnerable. Yeah.
And that's very much what happened in this case. It was it became clear that the person who offered the opinion had a hypothesis from the start before they got any information. They were actually in the media giving their opinion before they even had access to case materials. We didn't know that, though, because we were blinded to all of this information, which was great. But yeah, they're out there giving an opinion. Then they collected some information which was poorly acknowledged. We didn't know what it was, who it was coming from, and it all just got tied up into a nice just so story. But it contained errors and rumors and factual mistakes, and it just ended up being a document that the commission decided was so harmful to the families and to the people who had been involved that they refused to make it publicly available. They provided a summary sort of outlining what was in that document, but because of how problematic the content was, they decided it was not really fit for public consumption.
Well, sadly, it becomes, this is one person's story, because it's not based on evidence, and when people have been harmed, when there are people who are deceased, you've got loved ones who, I think it would be more painful to provide a story rather than a lack of evidence and just say we don't know.
Yes, and these were not neutral stories either, unfortunately. It took on quite a salacious air, and as a family member, it was obviously extremely distressing.
Yeah. But thankfully that's part of the I suppose the beautiful side of what an expert witness can do. You came in and reviewed that. As an expert witness, you were scrutinized around that as well.
We were scrutinized, that's right.
You were able to provide the evidence as to why you selected a methodology and why this report didn't stack up. Yes, there's probably lots of people who are upset. That's the point, is that we're not doing something to satisfy someone. We're just doing it on the basis of trying to be helpful for the court.
Yes.
And that's hard. That's incredibly hard. Because no one wants to be unpopular.
No, it is a piece of work that both Tess and I are very proud of. But it was extremely effortful. We were asked to do one thing and we did a much bigger thing, because you don't want to do half of a job when it's important. And in these kind of contexts, it was very important to us, but particularly because we have that sort of role as people who are interested in best practice. You have to walk the walk, right? So our report had to be what we think is best practice. And so it was kind of this very meta activity where we were talking about best practices and then also trying to live those best practices and show how they could be followed, how you could demonstrate best practice, and also where we couldn't. So we had big limitation sections in our report saying best practice would probably look like this. This isn't what we've done. Here are the reasons why. Here are the problems we see with that. Here are the strengths. And that's something I think experts really need to lean into, is that it's okay to say what your limitations are. It's a strength to know where your expertise ends, to lay out your weaknesses. Because in my experience, when we started by talking about sort of credibility attacks and that adversarialism, a lot of that interaction is about feeling caught out or being worried that you're going to get caught out about something. And if you can lay all your cards on the table and show that, for better or for worse, this is the evidence that you have and the capabilities that you have, then a lot of times there's not that much they can do. They can't catch you out because you've already told them. And if you're hiding it, that's something other than being objective. So we found it very empowering to say, here's all the things you might think are terrible about our report. We've already thought all of these things and we've written about them. And you're welcome to think whatever you like about them. Use them as you see fit. We felt protected, strangely, by having disclosed in the first place.
And I think that runs true to what an expert witness, from my understanding, should be doing. The limitations. An expert would know of the limitations.
They know.
Also is very. I think people would get great confidence from someone saying, I don't know, or this is the limitation, because we, it's almost like the higher someone goes up in rank in a, let's say, a large organization, the more likely they are to be able to say, I don't know, I'll get back to you.
Yes.
Because, we
The
just want
hallmark of
to do with
expertise.
facts. Yeah, we don't want a bunch of yes, men or women, or just fluff, because major problems with that. And either you have answers, but they are lies, and you're almost like a politician and you're just lying through your teeth all the time. My apologies, but I think it's happened too many times, and that my evidence tells me that I've seen.
No, we've heard that happen once or
not
twice.
all politicians. Let's not go there. But the more senior ranking that someone is, they've developed that skill, and quite importantly, sometimes an expert witness isn't necessarily a senior person, but they're an expert witness in the case. Because
they should be knowledgeable about the topic in which they're speaking, and there is research that tells us, and your intuition is correct, that the more you know about a thing, the more you see the shades of gray, right? The more you know that there is no simple answer here. There is no always or never. It's always under these circumstances or in these conditions, then this seems more likely than that. Or and that good people who are expert and who know their field are very happy to talk in those shades of gray. They're very happy to lay that out and to know their own limitations and to own them. They don't have that insecurity, or they shouldn't be insecure about that. It just shows that they know what they're talking about.
Their ego is not going to be harmed, and therefore they don't have to be defensive. They can just stand on the knowledge.
This is where we're at. This is what we know. Yeah. It's empowering, I think.
What sort of changes, if you could provide recommendations, and we can be a little bit idealistic here, what sort of changes would you put forward to how the legal system could improve on supporting expert witnesses and lay people to be able to communicate or to hear one another? Well, it's not a two-way conversation. For expert witnesses to be able to present in a way that lay people can get a better understanding of what the expert witness is trying to offer.
Yeah, I think I'm just trying. What's a good answer to that? There are lots of answers, but what's a good answer to that?
And you can throw a few of them around. I mean, some a little, but I think it all adds up. There's probably too many to think of, but there's some broad, maybe some broad brush ones too.
Yeah. Expert evidence can definitely be improved. Well, there are strategies that we can improve. So we're talking about, can we do a bit of better gatekeeping so that the real hokum doesn't find its way in the first place? That's vitally important. But there can also be, maybe we could think about modifying the justice system. Other people have suggested this. It's not my idea. I don't want to take credit for it. But the people who are usually in the best position to evaluate an expert are other people who know what's going on in that field. It's other experts who know. It's when you go speak to when senior psychologists talk together, then they can call each other out on their stuff. That's really where the action is happening. It's not usually when you have an expert and a novice talking that you can get down to the crux of the issue. So there are approaches where you might have experts, even if they're from opposing sides, which often happens, where they will discuss their assumptions and their opinions, and they'll crystallize what are the key points of difference. What are we actually disagreeing about here? And by working out what they actually disagree about, they can refine the scope of their testimony. So they're not talking about all this other irrelevant stuff. They can get to the point of the disagreement. That can be very helpful because it changes what is actually put in front of the jury. It's just the relevant things that would then go in front of the jury. So there's expert conclaves and hot tubs that are meant to help with that. You could imagine having panels of experts who do some preliminary vetting to make sure that this opinion is in step with the discipline and the field, and it's not saying anything outlandish, or if it is saying something controversial, that it has reason to do so, that there is an evidentiary basis. I don't think we should just be saying anybody who disagrees can't be permitted to testify. That's not what we want, but we need there to be some reason, some basis for that contrary position. Then it becomes kind of fanciful, because you've got this didactic lecture environment happening where jurors may or may not be permitted to take notes. If they want to ask questions, it has to be done sort of indirectly via the bailiff, not during a cross-examination. It's questions after the fact. You have limited resources, so witnesses aren't always really well prepared. Like you said, you hadn't had meetings with the defense before to go through things. You were waiting in the waiting room, and that's when you finally got to speak. So facilitating better preparation of witnesses by giving more resources to defense and prosecution. And then I think it's hard to imagine a situation where you train juries, because they are just sort of randomly plucked from the population. But upskilling experts in how to write reports that communicate the right sorts of bits of information, I think, would be useful. Upskilling judges in how to evaluate the evidence, all of those things, and I'm sure there are very many more, could help to smooth over this troublesome situation. But there's no silver bullet situation.
And is there, from your opinion or from what you've seen over the years, is there a mechanism in which the system is improving over time? These types of recommendations being put forward and considered from time to time? Is it a closed club which kind of says, we've been doing it this way for extended period of time, so we're not really open to suggestions at the moment because the old guard still in town? What's been your experience? And I know that in many professions it's much the same. Anytime you bring change, there's going to be hesitation.
Change sucks,
and for good reason, because once again, we almost need a very strong proposal as to why one thing will be far superior to another, and so on and so forth. And change is hard in that sense, particularly when you're changing an entire structure of how the law is applied. But is this changing? Is it evolving? Is it slow? Is it much more open?
I just literally today finished reading a book that was written in 2008, and I wrote on the front page, has anything progressed since then? Is anything any different now? I think, as I meant, it's a complicated system with lots of moving parts, which makes any change difficult. The legal system is a particularly slow beast, in part because the kinds of decisions it makes has such serious consequences that the idea of pivoting or acknowledging error or materially changing things has such dire ramifications for people who think their matters have been resolved, for victims who've got resolution, whether it was right or otherwise. But then you've got people who've been sentenced, and you've got precedent which has determined the outcomes of multiple cases. It's just a huge lumbering beast that's very difficult to interrupt. And there's definitely some pockets of the legal system that don't really see there's a problem or see it as somebody else's problem. It's not our problem, it's the expert's problem. It's not our problem, it's the legal fraternity's problem. All of those groups are able to look to somebody else. It's not my problem, it's somebody else's problem. So that's who's the responsibility lie with, and when are they going to take that responsibility? And I think the answer is multiple people are responsible for this problem, which makes it hard to solve. But then there are just fantastically proactive and motivated people within all of those organizations, you know, who see the problems, who are upset about how it looks, who want to make change for the better. And so certainly, I mean, the most proactive people, I work mostly relating to forensic science, so traditional forensic sciences. And, you know, some of the people who are making the most impactful changes are those forensic scientists who've been criticized for not being as expert as they need to be, not having their science house in order, so to speak. And they're working really hard to change that. But then there are other groups who are just under-resourced, overworked, and are finding it hard to get this to the top of the pile of a bunch of pressing priorities. So it's really a vexed problem.
Yeah, I can see it's hard to move such an incredibly large ship that has
set a course,
many consequences, and even if you were to place some change, I can imagine the challenges of saying we're going to make a change, but you know it's not going to happen until 2026, which could also then mean that everyone's pushing things across because they might see an advantage or disadvantage or whatever, and it just mucks things up. Then it poses the question of, well, if you're changing it, what's wrong with this current situation? So you're posing we're in an inferior system right now, and the previous
So
one.
what does that mean for my court case?
Let's bring back 1998 case of so on and so forth, because you have inferred that there was errors made back then and so on. And then you need big decisions to kind of grandfather everything in. But at the same time, there's major problems with doing that because we all know that the system hasn't actually been perfect.
No system will be perfect.
We're trying to help a community and people and individuals. And gosh, I can see why, it's easy to go and criticize, and at the same time, trying to think about how one might do it.
Yes.
You need a lot of will. You need a lot of group will, and coordination and intelligence and insight to try and make even the smallest of change. I can appreciate that.
Or you get a situation like what happened in, quite recently, the Queensland DNA inquiry, where hundreds of cases have had to go back and be reanalyzed because somebody found a problem in one case, and then that led to a public inquiry, and that discovered, problems underneath many cases, and then that opened up a reconsideration of hundreds of cases, if not thousands of cases. And the consequence, it matters. The fact that we don't have a perfect system now does matter. In this case, it was, victims not getting their justice because the science was not working the way that it should. But in other cases, it's convicted people, defendants not getting justice. So we just need to get that error to the smallest possible amount, so the system mostly works, and everybody's I would say almost everybody is perfectly well-intentioned and trying very hard, but there is still this room for improvement. And so that's where our attention is. We're just trying to make a good system better and better and better.
And that's hard to do in an unforgiving environment. It's easy
when mistakes matter.
I can, computer programmers can say we're on the 1900th iteration.
Patch, but just releasing another patch.
Just patch it up. We'll send it out. But it's not going out and costing people's lives, or people behind bars and all sorts of things. And how
what a stressful environment for everybody who's involved in it. When you think about, most of the time I go to work and I do my job, and my mistakes have relatively low consequences. There are some things I definitely wouldn't want to happen. I don't want to publish a paper that has a big mistake in it. That feels pretty impactful and terrifying to me. I want my science to be good science, but also nobody's going to jail at the end of my day if I've made a mistake. And for judges, for lawyers, for the people who do act as experts and give opinions, for the jurors, such big, significant consequences. It's a very tough environment.
I think it's a nice place to finish up on in terms of acknowledging, those in the profession, how difficult and stressful it is. We
Yes,
can easily
indeed.
criticize. The legal framework is clearly doing an amazing job, and that doesn't mean we can't improve. We should. I know
Yes.
that different models can be put forward. That's quite challenging as well. It's a space that we find ourselves in, and we should critique because we want improvement. Likewise with psychology, likewise
Yes.
with health, with education. It doesn't matter. Let's critique in a useful, constructive criticism, like we used to
Yes.
say in school.
Yes. Constructive.
But there's something to be said for that. So acknowledgement to that. Where can people find out more about this space, or continue on reading, listening, learning about the work that you do, and and potentially even get involved, so to speak?
So there is one paper I could point people to, which was a paper that we wrote after we did the work in Canada. So we wrote the report for the Mass Casualty Commission, and it outlined 8 best practices. We then wrote that up for annual reviews in law and social science, I think. And it's an open access journal article, but it's directed at psychologists who might be tempted to do expert work and who might be thinking about, how do I follow best practice and communicate the quality of my work to a legal audience? So I can provide a link to that article.
Yeah, if you provide a link, we'll put it into our show notes, and that way people can find it on betterthinking.com. Also, if I can ask you about what was how would you find that case, whether it's on YouTube or
so
what's the best way to try and find that easily?
So in the article, we have, so there are open science principles where people should be sharing their research materials freely among other researchers. So in the article, which is open access, there's also a link to an online repository, which has all of our reports and raw data and our coding, and everything anybody could ever want to find about that is linked to in the article. The case itself it's had a very long name, and I'm going to get it wrong. It's the Nova Scotia Mass Casualty 20. Here I look very bad because I can't remember the name of it.
That will be sufficient, because it won't matter about the year, because I'm sure there hasn't been too many mass casualties.
No, it was a public inquiry. It was the Joint Federal Provincial Public Inquiry into the April 2020 Nova Scotia Mass Casualty. I think that was the name.
I could
of the inquiry.
I can't understand why you couldn't remember it.
And there is a YouTube channel that was live streaming our testimony, and then live commenting on the live stream of our testimony, which is very humorous. I think that's linked to in our open access materials. So if you're looking for a interesting perspective, then you can see it there.
If you provide that link, we'll pop it in the show notes as well. And I did make an error. I said betterthinking.com. It's actually neshnikolic.com. So go, those listening, go to neshnikolic.com and you'll find those links. Thank you so much, Kristy. It's been so fascinating, and also hearing about your journey and experience as a N=1.
A fellow N=1.
I think it says a lot, though, and really talking about trying to integrate what best practice actually looks like and how difficult it can be. I think most people are trying to be as helpful and as useful.
Exactly.
Always limitations, whether it's writing a little letter to a GP or writing a letter to to support someone who's been injured in a workplace. All the way through to serious cases and being an expert witness and being on the stand and scrutinized in terms of cross-examination and the like. And I think it's a beautiful way to think about how we can do therapy as well, to be more considered of evidence to be more considerate of factual understandings, at least as a base. And knowing that there are huge limitations, there are huge things that we won't simply be able to know, but it's a nice framework to work from, whether it's therapeutically or in a forensic setting. So, yeah, thank you so much. Very refreshing conversation. And
it was my pleasure. I'm sorry for boring you with all of my talk about experts.
Thanks, Kristy.